H.R. 6355. Public. Note 75 68th Congress. Certi 8th Congress of the United States of America. At the first session. Begun and held at the City of Washington on Monday, the 3rd day of December, 1923. To authorize the Secretary of the Interior to issue certificates of citizenship to Indians. Be it enacted by the Senate and House of Representatives of the United States of America in Congress assembled, that all non-citizen Indians born within the territorial limits of the United States be, and they are hereby, declared to be citizens of the United States, provided, that the granting of such citizenship shall not in any manner impair or otherwise affect the right of any Indian to tribal or other property. Speaker of the House of Representatives. Hatemji President pro tempore of the Senate. 2.24 cents, 62.44. AEF Clare. Juni 2, 1924. Deartwin to FSTAS. PT. Stat. UNO 24. UISONFLTUDI Catio. COVID-19 updates and information following guidance from the White House. Centers for Disease Control and Prevention. Official website of the United States government. Here's how you know U.S. Department of the Interior. Indian Affairs. What is the Snyder Act of 1921 and who does it apply to? Submitted by Broyles, Robin on Friday, October 20, 2023 2001. FAQ Category. Menu. Our nation's American Indian and Alaska Native citizens. The Snyder Act of 1921 authorizes Indian Affairs to operate programs for the benefit and assistance of American Indians and Alaska Natives throughout the United States. The act is one of several legislative reforms that was designed to improve the living conditions for American Indians on reservations and in government boarding schools. The Indian Citizenship Act of 1924, also known as the Snyder Act, was signed into law by President Calvin Coolidge on June 2, 1924, granting full citizenship to American Indians and Alaska Native Americans. Though the 15th Amendment, passed in 1870, granted all U.S. citizens the right to vote regardless of race, it wasn't until the 1924 that American Indians and Alaska Native Americans could enjoy the rights granted by this amendment. Today, Indian Affairs provides services directly or through contracts, grants, or compacts to a service population of approximately 2 million American Indians and Alaska Native people who are members of 574 federally recognized tribes in the 48 contiguous United States and Alaska. Indian Affairs programs support tribes and improve the quality of life of their members and communities. U.S. government documents related to indigenous nations. The 2nd of June 1924. United States Congress. University of North Dakota. UN Scholarly Commons. An act to authorize the Secretary of the Interior to LSSUE certificates of citizenship to Indians. Elwin B. Robinson Department of Special Collections. How does access to this work benefit you? Let us know. Recommended citation. Follow this and additional works at https://commons.un.edu/indigenous-gov-docs. Part of the American Politics Commons, Indigenous, Indian, and Aboriginal Law Commons, Indigenous Studies Commons, Law and Politics Commons, Native American Studies Commons, and the United States History Commons. An act to authorize the Secretary of the Interior to issue certificates of citizenship to Indians. Public Law 175. Statutes at Large 43, 1924, 253. https://commons.un.edu/indigenous-gov-docs/130/. This public law is brought to you for free and open access by the Elwin B. Robinson Department of Special Collections at UN Scholarly Commons. It has been accepted for inclusion in U.S. government documents related to indigenous nations by an authorized administrator of UN Scholarly Commons. For more information, Please contact und.commons@library.und.edu. Statutes at large. At United States of America. From December 1923 to March 1925. Concurrent resolutions of the two houses of Congress. And recent treaties, conventions, and executive proclamations. Edited, printed, and published by authority of Congress under the direction of the Secretary of State. In two parts. Part Public Acts and Resolutions. Part 2, Private Acts and Resolutions, Concurrent Resolutions, Treaties, and Proclamations. Part 1. VASHINGTON. Government Printing Office. 1925. 68th Congress. Sess. I. CHS. 231 to 234. 1924. Patents in fee, or any other disposition authorized by existing law relating to Indian allotments. Approved, June 2, 1924. Chap. 232. An act to provide for the addition of the names of Chester Calf and Crooked Nose Woman to the final roll of the Cheyenne and Arapaho Indians, Seeger Jurisdiction, Oklahoma. 253. Chap. 233. An act to authorize the Secretary of the Interior to issue certificates of citizenship to indizens. Be it enacted by the Senate and House of Representatives of the United States of America in Congress assembled, that the Secretary of the Interior be, and he hereby is, authorized to add to the final roll of the Cheyenne and Arapaho Indians of the Seeger Jurisdiction, Oklahoma, approved May 18, 1921, the names Chester Calf and Crooked Nose Woman, which names were inadvertently omitted from the said roll, and to pay to each of these persons a sum equal to that heretofore paid per capita to those whose names appear on the approved roll, such payment to be made from any tribal funds to the arredat of the Cheyenne and Arapaho Indians. Approved, June 2, 1924. Approved, June 2, 1924. Chap. 234. An act to reduce and equalize taxation, to provide revenue, and for other purposes. Be it enacted by the Senate and House of Representatives of the United States of America in Congress assembled. Title I General DEFINTIONS. Be it enacted by the Senate and House of Representatives of the United States of America in Congress assembled, that all non-born and United Citizen Indians born within the territorial limits of the United States declared CITK states be, and they are hereby, declared to be citizens of the United Proriso States, provided, that the granting of such citizenship shall not not at, in any manner impair or otherwise affect the right of any Indian to tribal or other property. 1. The term person means an individual, a trust or estate, a partnership, or a corporation. June 2, 1924. IH.R. 6857. Public, No. 174. J. 2. The term corporation includes associations, joint stock companies, and insurance companies. Names added to FNAL. 5. The term United States when used in a geographical sense includes only the states, the territories of Alaska, Hawaii, and the District of Columbia. Per capita payment. 6. The term Secretary means the Secretary of the Treasury. 1. The term Commissioner means the Commissioner of Internal Revenue. June 2, 1924. ER 6355.1 Public, Number 175. Indians. Zens. 253. Fected. Section 1. This act may be cited as the Revenue Act of 1924. TTLE of et. Sec. 2. Up when used in this act. June 2, 1924. H. R.6715. Public, Number 176. Revenue Act of 1924. General definitions. Terms construed. Person. 3. The term, domestic, when applied to a corporation or part domestic, Nurship means created or organized in the United States or under the law of the United States or of any state or territory. 4. The term, foreign, when applied to a corporation or part, foreign. Nurship means a corporation or partnership which is not domestic. Corporation. United States. Secretary. 4. Commissioner. Control number 1076-0017. Expires June 30, 2017. In reply refer T0. Interview date. United States Department of the Interior. Bureau of Indian Affairs. Application for Financial Assistance and Social Services Instructions. Washington, D.C. Any individual or family may apply for Bureau of Indian Affairs Financial Assistance and Social Services by completing the application process with the assistance of the social services worker and providing the following required information: proof of tribal membership, proof of residency, proof of income and resources. Failing to provide this information may result in denial of financial assistance and social services. 1849 C Street, NW Washington, D.C. 202402002, 513-7673. Directions for completing application for financial assistance and social services form. Please fill in your name, tribe, physical address, phone number, mailing address, if different from physical address, or provide directions on how to get to your home. Please also respond to the 2 questions. Section I. Family profile of head of household members applying. Section 3. Earned and unearned income. Under family profile, fill in the following information to the best of your ability. First, start with yourself. Please fill in your name last, first, middle, date of birth, DD, YYYY, sex, F, your marital status, the highest education level received, social security number, and finally your tribal enrollment number. Next, complete the names of the total members of the household, then children in descending order of age. FUTD statung with your spouse and T. For each member list the birth date, sex, and relation, head of household, marital status, highest education received, social security number, and tribal enrollment number. If you are living in a household with more than one family, list the family members that fall under your household. Section 2. Types of financial assistance and social services. Earned income. Put a check mark in the boxes for the services you are applying. This will assist your social services worker in determining which portions of the application you will need to complete. Unearned income. All income, including earned and unearned income, for yourself and any other person in your household, is to be listed on the application. You are required to provide proof of income. Is cash or any in-kind payment earned in the form of wages, salary, commissions, or profit by an employee or self-employed individual. This includes one-time payments for ongoing activities such as sale of crops or sale of artwork. Self-employed individuals must report profits from business enterprises, gross receipts minus business expenses included in the production of goods or services. Business expenses do not include depreciation, personal transportation costs, capital equipment purchases or principal payments on loans for capital assets or durable goods. 25 CFR 20.308. Includes but is not limited to interest, royalties, gaming income or other per capita distribution not excluded by federal statute, rental property, cash contributions such as child support or alimony, gaming winnings, retirement benefits, annuities, veterans disability, employment benefits, and tax returns. Other types of unearned income include financial assistance from government, income from sale of trust land or other real or personal property set aside for investment in trust land that has not been reinvested in trust land, or a sale of a primary residence that has not been reinvested in a primary residence at the end of 1 year from the date the income was received, and in-kind contributions providing free shelter up to the 25% of the amount for shelter included in the state standard. 25 CFRS 20.309. Under Section 2 and Section 3, please complete questions 1 to 4 to the very best of your ability based on the information provided above. If you are unsure of the question, please ask your social services worker for assistance or clarification. 1. Slip Opinion. October Term, 2022. Syllabus. Note: where it is feasible, a syllabus headnote will be released, as his syllabus constitutes no dart of the opinion of the court but has been prepared by the reporter of decisions for the convenience of the reader. See United States v. Detroit Timber and Lumber Company, 200 U.S. 337. Syllabus. Supreme Court of the United States. Holland, Secretary of the Interior, ETAL. V. Brackeen et al. 1. CERTIORARI to the United States Court of Appeals for the Fifth Circuit. No. 21 to 376. Argued November 9, 2022, decided June 15, 2023. This case arises from 3 separate child custody proceedings governed by the Indian Child Welfare Act, ICWA, a federal statute that aims to keep Indian children connected to Indian families. ICWA governs state court-ordered adoption and foster care proceedings involving Indian and children. Among other things, the Act requires placement of an Indian child according to the Act's hierarchical preferences, unless the state court finds good cause to depart from them. 25 U.S. C. S. 51915 A.B. Under those preferences, Indian families are institutions from any tribe, not just the tribe to which the child has a tie, outranked unrelated non-Indians or non-Indian institutions. Further, the child's tribe may pass a resolution altering the prioritization order. S. 1915 c. The preferences of the Indian child or her parent generally cannot trump those set by statute or tribal resolution. In involuntary proceedings, the Act mandates that the Indian child's parent or custodian and tribe be given notice of any custody proceedings, as well as the right to intervene. $1912 A.B.C. Section 1912d requires a party seeking to terminate parental rights or to remove an Indian child from an unsafe environment to satisfy the court that active efforts have been made to provide remedial services and rehabilitative programs designed to prevent breakup of the Indian family, and a court cannot order relief unless the party demonstrates, by a heightened burden of proof and expert testimony, that the child is Togut Ne text with number 21 to 377, Cherokee Cherokee Nation et al. Versus Brackeen E et al. Number 21 to 378, Texas versus Holland, Secretary of the Interior, et al., and number 21 to 380, Brackeen et al. Versus Holland, Secretary of the Interior, et al., also on certiorari to the same court. 2 Holland v. Brackeen. Syllabus. Likely to suffer serious emotional or physical damage if the parent or Indian custodian retains custody. 1,912 Singapore dollars (DE). Even for voluntary proceedings, a biological parent who gives up an Indian child cannot necessarily choose the child's foster or adoptive parents. The child's tribe has a right to intervene at any point in a proceeding, to place a child in foster care or terminate parental rights, as well as a right to collaterally attack the state court's custody decree. $51,911 c. 1914. The tribe thus can sometimes enforce ICWA's placement preferences against the wishes of one or both biological parents, even after the child is living with a new family. Finally, the states must keep certain records related to child placements, CS 1915E, and transmit to the Secretary of the Interior all final adoption decrees and other specified information, CS 1951A. Petitioners, a birth mother, foster and adoptive parents, and the state of Texas filed this suit in federal court against the United States and other federal parties. Several Indian tribes intervened to defend the law alongside the federal parties. Petitioners challenged ICWA as unconstitutional on multiple grounds. They asserted that Congress lacks authority to enact ICWA and that several of ICWA's requirements violate the anti-commandeering principle of the 10th Amendment. They argued that ICWA employs racial classifications that unlawfully hinder non-Indian families from fostering or adopting Indian children. And they challenged S. 1915(c), the provision that allows tribes to alter the prioritization order, on the ground that it violates the non-delegation doctrine. The district court granted petitioners' motion for summary judgment on their constitutional claims, and the en banc Fifth Circuit A.F. affirmed in part and reversed in part. The Fifth Circuit concluded that ICWA does not exceed Congress's legislative power, that S. 1915(c) does not violate the non-delegation doctrine, and that some of ICWA's placement preferences satisfy the guarantee of equal protection. The Fifth Circuit was evenly divided as to whether ICWA's other preferences, those prioritizing other Indian families and Indian foster homes over non-Indian families, unconstitutionally discriminate on the basis of race, and thus affirmed the district court's ruling that these preferences are unconstitutional. As to petitioners' 10th Amendment arguments, the Fifth Circuit held that $1,912 D's active efforts requirement, S. 1912(e)(s) and S. 1912(f's) expert witness requirements, and S. 1915(e)(s) record-keeping requirement unconstitutionally commandeer the states. And because it divided evenly with respect to other child length provisions, S. 1912(a)(s) notice requirement, S. 1915(a) and $1,915 B.S. placement preferences, and $51,951 record-keeping requirement, the Fifth Circuit affirmed the district court's holding that these requirements violate the 10th Amendment. Google to read more. This is an 133-page PDF. We are indigenous. Our land was stolen. Yet millions will celebrate Thanksgiving, which was the slaughter of my indigenous, Aborigine, Kemet ancestors. It goes to show the ignorance of the blind, deaf, and dumb. Everyone has free will. My Father will never take that from us. As a whole, we must understand what we are celebrating and why. Be conscious of the energy you are giving. Things are not as they appear to be, and these holidays are set up for a reason. How can we know the truth about how our people was slaughtered, raped, giving diseases, and celebrate our people being put in poverty, being treated less than? Every day we as a whole should celebrate our family and friends. A holiday should not be an excuse for us coming together, eating and enjoying life.